It is now my pleasure to introduce to you our 2017 commencement speaker, the Honorable Louis Sands, Senior Judge of the United States District Court for the Middle District of Georgia. Judge Sands' distinguished career would make him a fitting speaker to mark the occasion of a new group of Mercer Law School students becoming lawyers. But of course, he has more in common with the class of 2017 than just sharing membership in the legal profession. Because, like the class of 2017, Judge Sands' legal career began upon his entering Mercer Law School. Now, he wasn't new to Mercer at that point. He is what we call a double bear. Judge Sands earned his Bachelor of Arts degree from Mercer University from before he began law school, from which he graduated in 1974. Since that time, Judge Sands has had an extraordinary career, serving in the United States Army Reserve as an assistant district attorney and then as an assistant United States attorney before becoming a judge of the Superior Court here in Macon and then being appointed to the federal bench in 1994. He served as Chief Judge of the United States District Court for the Middle District of Georgia from 2001 to 2006, and he took senior status in 2014. Judge Sands' commitment to public service and to using his time, talents, and purpose to improve the legal system is emblematic of our motto that Mercer lawyers are prepared for practice and committed to serve. Judge Sands' influence and service have made a difference in so many areas, including here at his alma mater. He currently serves on the Mercer University Board of Trustees, and this year he served the law school as chair of the law school's Dean's Search Committee. Judge Sands frequently serves as a mentor to our law students in a variety of ways, as a mentor and sometimes employer of our graduates, and I know from personal experience that when the law school calls on him for any reason, the answer is always yes. Please join me in welcoming our commencement speaker, the Honorable Louis Sands.
At this stage, you have to make sure you have your glasses and everything in place so you know where you are. Good morning. Good morning. All right, thank you. That sounds good. I know that some of you need to be awakened, so this is an opportunity to do that. To Provost Davis, Dean Floyd, distinguished faculty members and staff of Walter F. Joyce School of Law, families and friends of today's graduates, and of course, members of the class of 2017. It is my great pleasure, honor, and privilege to share with you this momentous occasion of personal and educational accomplishment. Now, members of the class, today you become graduates, holders of the degree of Juris Doctor. And very soon, for most of you who wish to, memberships to that class of individuals authorized to practice law. You are to be congratulated on your achievement, which in turn positions you for the acquisition of even a greater privilege. Now, I will not give you a lecture today because you've enjoyed and endured hundreds of them over the last 3 years from faculty more adroit at that task than I. You need not fear being called upon to brief a case or give an on-the-spot analysis of a legal principle or apply it to an ever-changing composite of facts. There will be no reference to legators, legatees, transferors, transferees, appellants, appellees, petitioners, or respondents. I will not mention the rule in Shelley's case, the rule against perpetuities, Erie, Twombly, or Iqbal. You've had enough of them. Today is a day of celebration, or for the more spiritual among you, a day of thanksgiving and excelling. This is a day to relish in your accomplishment and to look forward to bright and successful futures So instead of the usual, I want to briefly mention a few points I suggest you consider today and regularly revisit as you go about your legal career or however you may choose to use your legal skills. Briefly, because I know why you're really here and what you're really anxiously awaiting. A long-awaited conference of your well-earned degree, your velvet hood of purple, your diploma, and lunch. I know that you're not only anxious, but perhaps a bit tired from celebrating and the resulting lack of sleep. So I don't wish to be like the lawyer who appeared before my late former colleague, Judge J. Robert Elliott. A lawyer was making his closing argument, and when doing so, he noticed that a juror had gone to sleep. So he quietly approached Judge Elliott and told Judge Elliott, and Judge Elliott responded, "Well, what do you want me to do about it? You put him to sleep, you wake him up." So in order to avoid that circumstance, I now appoint and authorize each of you to nudge your neighbor if he or she happens to drop off. Hopefully you gave serious consideration to your decision to study law and become a lawyer. The consideration and recollection of the reason or reasons for your decision not only allow you to reassess your decision today, but to revisit and reconfirm them as you go about your career. I remind you that as a result of your education here at Mercer, you are special. You are special because you have developed and will continue to develop special skills. Second, you are both powerful and responsible because the special skill set you now possess makes possible an exclusive privilege. Third, because of that exclusive privilege, you along with the profession will also be accountable to clients and the greater society whose interests exist, operate, and interact under the rule of law. I well remember my inspiration to attend law school and become a lawyer. My interest vividly revealed itself to me in a political science class on this campus more years ago than I care to acknowledge. The class was a 2-quarter course on the United States Constitution taught by Dr. James Cox, political science professor and lawyer. The first quarter essentially involved the historical survey of the country as it had developed and as it had grown. The second quarter involved a review of decisions of the United States Supreme Court, overlaid the historical survey of the previous quarter. Immediately, I observed with a great deal of excitement that the law was seemingly involved in virtually every aspect of the society's development. Law touched and affected virtually everything through its application. If an issue, a right, or conflict was important, somehow the law affected the outcome. Previously, I had grown up largely in a legally segregated society and had personally experienced firsthand the effects of unjust laws, inequality, and injustice. Just as I had observed those cases in those classes, I realized that law had played a significant role in my own life, sometimes effectively, sometimes ineffectively, and sometimes disastrously. Those effects stood strikingly and starkly against a constitutional backdrop painted with inspiring words such as equal justice. In the early 70s, there were few African American, minority, or women attorneys. Likewise, such judges were virtually non-existent. There were few representatives of these groups in law schools during that time. A female classmate and I joked that the two of us controlled the minority in our graduating class. You see, she was the only woman and I was the only African American. All our other classmates were white males. To the contrary, today, you are part of a vastly more diverse class. I concluded that without meaningful access to effective legal representation, actual and full citizenship were not available to many. I concluded and believed that law could and should address many, if not all, of the inequities and wrongs which had plagued so many so long. In short, I saw the law profession as one in which I could expect to make a reasonable living while providing valuable legal service to those who needed them and to those who had been denied them all too often. I similarly believe that through a career in law, I could not only make a positive difference for individuals, but as a result of my own practice, I could also improve circumstances for the broader society. In my view, my own actions could help to make the legal system fairer, more just, and equal. A rosy view? Indeed. However, I sincerely believed it not only to be a possible reality, but a worthy cause. As I said, you are special. You are special because over the last 3 years, you've developed the skills of a lawyer. I am sure you remember the approach and production of your work as a student in high school and undergraduate school that served you so well, only to face sheer terror in law school. No longer were you simply giving back what you had learned in your classes and studies so successfully in your previous matriculations, but now you were consumed by legal reasoning, analysis, and application. You discovered, and often to the shock and disbelief of non-lawyers, that two opposite answers to the same question can both be correct, and that when it came to virtually any answer, the condition, "it depends," must be added. Soon after you began law school, when a relative or friend presented you with a problem or an issue, you immediately listened carefully, separated and sorted the facts, threw out the irrelevant ones, placed the remaining ones in descending order of importance, and asked even more facts and for more clarifications. Then you classified the subject area, retrieved the relevant controlling principles, and then finally pronounced your guarded response. And often the person would subtly respond to you, and perhaps for the first time, they'd see the problem clearly. And they would say, "Oh yeah, that's it. I see what you're saying. I understand now." So you had succeeded in taking an amalgamation of factual clutter and distilling from it relevant facts, succinctly stating the issue and applying sound principles and reasoning. The law requires that ability, and no other profession is better suited to those tasks than the law profession, you. However, though, I must add this, and I hope that the parents and friends will understand what I'm saying. I think they'll join me in this opinion. You've also developed a weakness. You become frustrated when someone says something like, "John, Susan, William, and Tiffany went to the restaurant. As soon as they went in, he said," and you stop them, "What? Who is he?" Now, believe me, they understand too that that's a problem, because they obviously understand what they mean. And what I'm saying to you is this: you will always, forever be handicapped in normal conversations. The valuable skills you've developed over the past 3 years will be used in the interest of others. You are especially capable of identifying and solving complex legal and related matters, or simply in helping someone make a sound and reasonable decision regarding a matter of importance. Since beginning law school, more and more questions have come from family, friends, and acquaintances. That will continue because others recognize, understand, and appreciate the value of your knowledge and skills. Years ago, during a commencement speech at another law school, I reminded the graduates that we as lawyers are granted an exclusive privilege, that of representing the legal interests of others. Non-lawyers may only represent themselves, no one else. That is why you are not only special, but you are both powerful and responsible. Since only lawyers are permitted to represent others in legal matters, we are responsible to provide effective legal representation. With our important privilege, then, comes great responsibility. We must, as a consequence, be diligent, effective, and timely. A failure at either of these requirements can result in real harm to those we are legally obligated to represent. No doubt you have worked hard. However, the hard work has only just begun, and the hard work in your future will count for far more than a good grade or higher class rank. Each case, legal task, or advisement you undertake will rely upon your professionalism, knowledge, and efficacy. Hopefully, in exchange, you will be well paid, but the hard work is unavoidable and inevitable. This is yet another reason to periodically recall and visit the reason you decided to become a lawyer. And lastly, the profession, because of its exclusivity, is accountable. We are accountable as a profession to provide to our clients and the society what we assert should be our exclusive privilege, because as we see it, only we are adequately equipped to do so. If we fail to be concerned about identifying and creating meaningful solutions for broad, reasonable access to legal services, then our fellow citizens can rightly consider and ask whether we deserve or should be permitted to maintain our, up to now, exclusive privilege. They may justly look elsewhere and to others. Today, it is doubtful that significant numbers of the middle class can easily afford legal representation. As you know, legal representation for indigent criminal defendants has long been an ongoing challenge. Likewise, representation of indigent civil parties is the subject of more and more attention and concern. This is so because personal rights, interests, and even individual liberties can be at risk in what are technically civil matters or proceedings. For instance, a person can be jailed for failure to pay a fine, or incarcerated for failure to pay support, or certain other obligations. The question is not so much of whether such sanctions should be prohibited, but rather whether they should be risked in proceedings where there is no reasonable access to effective legal representation. These are problems for which the profession must bear and share responsibility. Already, the exclusivity I refer to has become less so, even if ever so slightly. The ABA issued its 2016 report on the future of legal services in the United States. The organization's Commission on the Future of Legal Services notes unmet needs and supports creative efforts to address those needs. ABA Resolution 105 sets out model regulatory objectives to guide states in the regulation of non-traditional legal services. One such program has been established in the state of Washington. There, the Washington State Supreme Court recognizes limited license legal technicians, LLLTs. Non-attorneys are permitted to provide limited assistance in family law disputes. The state is now also considering a proposal to expand LLLTs to include the areas of estate planning, probate, guardianship, healthcare law, and government benefits. At present, these LLLTs are not allowed to represent their clients in court and cannot negotiate with opposing counsel on their client's behalf. Certified programs are under review or consideration by the New York City Bar Committees, a Committee on Professional Responsibility, the State Bar of California, and the State Bar of Oregon. However, thus far, neither has launched such a program. One state bar, has strongly opposed such programs. That's the state of New Jersey. The bar states, quote, is strongly opposed to allowing non-lawyers to provide any kind of legal services, even in a limited fashion, close quote. Per the bar, allowing such programs, quote, will create a tiered system of justice that will imperil those most vulnerable in our society. I pose a simple and straightforward question. Can a limited certificate program in such areas as domestic relations and estate plannings equate to the years of legal studies you have experienced? Effective legal representation and practice require far more than simply downloading and filing form pleadings. I must say, though, in light of that, often lawyers get a bad rap. Apparently that did not affect your decision. Now, some I've heard on television, they even apologize for having been lawyers, and they shamelessly say things and refer to themselves as, quote, recovering lawyers. I hold the contrary. The practice of law is a wonderful, challenging, rewarding, and most importantly, an honorable profession. Now, William Shakespeare is often quoted, and more often misquoted, by some in an effort to spear the profession through what is presented as an apparent long-standing historic characterization of lawyers and the profession. Kill all the lawyers, the quote is often stated. However, the accurate quote from Shakespeare's play, Henry VI, Part 2, Act 4, Scene 2, line 73, is, quote, the first thing we do, let's kill all the lawyers, close quotes. Now, in context, the characters have plotted those of you who had English literature backgrounds, you remember that plot was about a takeover of the kingdom with the goal of crowning one of the plotters as king, and they were to do this through the intentional creation of social chaos. So the plotters reasoned, in effect, that in order to give their plan for chaos-driven revolution the best chance for success, the first thing we do, let's kill all the lawyers. In the time of Shakespeare's play as today, lawyers played a key role in maintaining an orderly, civil, and stable society. Thus, it can be argued persuasively that if one wishes to have a chaotic society, one without any rules, without any stability, then the first thing you should do is to get rid of the lawyers. However, I believe that few would seriously consider or advance such a goal or method. Now, lastly, I want to share with you one of my most important cases. It was not a big case. It did not involve a large fee. It was not even a court case. It was a hearing before an administrative hearing officer. As I suggested earlier, I grew up not far from here in rural Jones County. A woman who I had known from the time I was a child called me and told me of her pending hearing where it would be decided whether she would be terminated. Now, notwithstanding her challenges of an impoverished childhood, she had been able not only to finish high school, but to become a licensed practical nurse, as they would refer to themselves, LPNs, so proudly. She had worked in her field for years at a state-run institution. She was very proud of her skills, her work, and her accomplishments. However, her spirit was down. She had only decided to call me the day before her hearing, thinking that maybe I could help her in what she saw as a dire and hopeless situation. She told me that the matter had arose from her care of a patient shortly before daybreak where she had been the LPN on duty, and an incident occurred where a patient previously known to physically attack other patients had indeed attacked another patient and had caused grievous, life-threatening head injuries. She had immediately interceded, attended the injured patient, and called for an ambulance to transport him to emergency care at a hospital. Tragically, the patient later died that morning. Almost immediately, she had been suspended and noticed of the intent to terminate her employment. In effect, she had been blamed for the patient's death. The suggestion was that if she had performed her duties correctly and appropriately, the patient very likely would have survived. Now, for you soon-to-be lawyers sitting out here, and if you're listening very closely to what I said, you probably recognize the actual apparent and underlying reasons for the supervisor's allegation. I accepted her case. I sought and obtained a continuance for the hearing so that I could investigate the matter, and I investigated it. And when the new hearing date had arrived, we were ready. I had the records from the hospital, from the institution where she worked. I had the ambulance records, photos. Actually, I had reconstructed moment by moment the sequence of the events. My client at that hearing sat there quietly and listened as her supervisor set out her reasons for concluding that her performance had fallen below professional standards. During our turn, we presented the testimony of the emergency physician who had attended the injured patient. After establishing the relevant supporting facts, I put the question of my client's performance to the doctor. Step by step, he explained what she had done and that she had done exactly what a person in her position, with her knowledge, experience, and training should have done. In other words, her professional attendance to her patient had in no way contributed to his death. The hearing ended with the findings of the hearing officer who recounted the pertinent facts shown by the evidence and the standards that he applied. As he made his favorable findings, I just happened to notice, I looked at my client, and the person who had been slumped in her chair, dejected, she began to sit up. She sat up straight. Her dignity and self-esteem returned. The officer, of course, found in our favor. She was now free to continue in the career that she had chosen and of which she had been so proud. The next day she called me. She was so happy and she was upbeat. She thanked me again and shared how her co-workers and even her supervisor had welcomed her back to work. And she added, everybody wanted to know who that lawyer was. And of course, that was referring to me, and I kind of felt all pumped up a bit. But during that phone call, I recalled why I had become a lawyer. I had made effective legal representation available to someone who lacked significant financial means or great social status or influence. I had made a difference in a person's career, in a person's life. I had used my special skills to make matters for that client, for my client, more just, fair, and equal. I had used my power, and I had used it responsibly. I had been accountable to my client and to society. Becoming a lawyer is not easy. Law practice is difficult and demanding. Being an effective lawyer is especially demanding. However, lawyers are perfectly equipped to meet the critical needs and demands of the members of a society who choose to live, thrive, and interact under the rule of law. The benefits include a more civil, safe, predictable, and stable society. Anyone engaged in or choosing to engage in such activity for good, sound, and moral reasons is indeed engaged in a valuable and beneficial activity and service. These are lawyers, members of an honorable profession. The practice of law is more than an abstract engagement in philosophy, and more than a mere exercise in reason for its own sake. Law has real application, and the practice and its absence affect the lives of real people. There are consequences to the practice of law, our exclusive privilege. The rapid growth and ever-broadening application of technology and globalization create and drive changes in our modern society. These changes come about with ever-increasing acceleration. The law and the practice of law must catch up and keep up. Members of the graduating class, you will be challenged to make necessary adjustments and responses to those changes as you practice and yet maintain the highest levels of professionalism, effectiveness, and efficiency. Now, isn't that exciting? What a challenging yet wonderful future for you to look forward to. Remember, there will always be a need and place for good lawyers. You only need to find them. I again offer my most sincere congratulations to you and to your families and friends. They too played an important part in your success and accomplishment. So I will leave you now with the same salutation I gave to a university graduating class a couple of years ago in this same space. I'm a lover of science fiction. I guess I describe myself as an almost Trekkie. So in the spirit of that extremely intelligent, objective, analytical, and emotionalist, lawyer-like, intergalactic space adventurer, Dr. Spock, go forth and prosper. Thank you.